It's great to be back with all of you. Welcome to September. I'm hopeful that all of you enjoyed meaningful Labor Day holiday weekends. And for those of you, as I am, getting your kids ready to head off to school, that thus far the transition is going well. If you are a tennis fan, it's week 2 of the US Open, so time to really tune in and pay attention. We have a full program and I'd love to walk you through all the details of it. Right now, of course, I'm giving you some background on what's ahead. Right after I'm done, you'll hear from Britt Shep Wong. She's a attorney who brings a wealth of experience in higher education, including in-house and other stops, who recently joined our higher ed practice in New York City, sitting adjacent to my desk. And we're thrilled to hear from Britt on legislation that's just been signed into law by the governor that affects our New York City institute, or rather New York State institutions, excuse me. Kim Walcott-Agree is going to be back on. Kim is with us from our Westchester office, and Kim is going to be looking at legislation that hasn't been signed, but that percolates every year, it seems, certainly for the last few, the so-called Wrongful Death Act, and we'll get the latest on where that stands. Julian Jin, heading back to our New York City office, will be following up on a piece that she wrote earlier in the year concerning changes in essentially the oversight of networks relating to managed care organizations and behavioral health. There are more details. What we've noticed is that the state's attorney general has begun some enforcement activity in the space, and we wanted to catch you all up on that. Mark Saraceno is going to bring a change of pace and talk with us a bit about baseball. It is not only US Open time, but just across the street at formerly Shea Stadium at Citi Field, where the Mets play. The Mets are trying to hang on to what looks like a playoff spot if they don't keep losing. This is as a Mets fan I'm speaking. And Mark, a fellow Mets fan, is here to take a look from a legal perspective at the Juan Soto contract, one that was signed, yes, a few months ago, but we haven't really had a chance to unpack it. And it's an interesting and unusual bit of legal framing that we wanted to give you a chance to think about with us and to get to know Mark a bit better. So with that, I'm going to hand over to Britt, but let me just more formally introduce Britt because, as I mentioned, she brings a wealth of experience to our firm, and we're delighted to have her on behalf of the service that really she'll be providing to many of you in higher education and beyond. She's had stints at NYU and the Fashion Institute of Technology and at Penn State, and she's also been a federal clerk in the past, all of which rolls up into someone who really knows a lot about the area of the law that she is going to continue guiding clients on. And we're delighted that she has made the choice to join our firm and work with all of you. With this new legislation that's been signed into law, we thought it was a great opportunity for you to get to know Britt a little bit better. And so, Britt, the floor is yours. Welcome.
Thank you, Gabe, for that kind introduction. So as you mentioned, I'm here to share an update on a new law impacting higher ed institutions across New York State. I know we often have a lot of college and university stakeholders that join us for this weekly call. So I'm glad that some of you are here today. Though I also know that a number of you are joining us from other industries. And although this law only applies to colleges and universities, I'll do my best to highlight a couple places where you might look to this law as sort of inspiration for best practices and as a chance to sort of take stock of some of the non-discrimination programs that you all may have, where there could be parallels. It's obviously also just sort of a newsworthy interest given the increased attention to Title VI issues facing institutions across the nation in the past couple of years. So last week, the governor signed into law, backed by bipartisan support in both legislative chambers, a new section to the education law that requires the appointment of a Title VI coordinator. So This is the first of its kind law in the entire nation. Is actually really interesting because it is going beyond what the federal law currently requires. There have been sort of specific one-off instances where the federal Department of Education has required specific institutions to create a Title VI coordinator in resolving specific investigations. But as of now, we don't have Title VI regs in the same way that we do under Title IX. And that would mandate particular, parts of the process and mandate a position like this. So this is a really interesting move by New York State to sort of get out ahead on this issue, even beyond what the federal government is doing. So most of you know, Title VI is a part of the civil rights laws that protects on the basis of race, color, and national origin, which has been interpreted to also extend to shared ancestry and ethnicity in any program or activity for those that are receiving federal funds. This is not the first time that New York State has legislated in an area that overlaps with the federal civil rights law. Many of our institutional clients will be by now well familiar with 129B, which mandates particular institutional responses to sexual assault, domestic violence, dating violence, and stalking. And so in those ways, it overlaps with Title IX and the VAWA amendments to the Clery Act. So this is another instance where we're seeing, again, the New York State make a move sort of related to and connected to federal law, but kind of going out on their own. So what does the law actually require institutions to do? The first and sort of critical component, if we could advance to the next slide, please, is to appoint a Title VI coordinator who will serve as a central point of contact for coordinating and overseeing a centralized process for compliance with Title VI. And one question that might immediately come to mind for institutions is, how are we going to fill this position? Can it be, a dual role held with our Title IX coordinator? The law does provide for flexibility in how it is filled. It can be fulfilled through a single role or through a dual role, or potentially even a big team. And these are the types of things that I think institutions are going to want to really think about as they are figuring out how to comply with this new role, is to think about historical incident volume, capacity in those existing roles, the reporting structures of those existing roles, and how a Title VI coordinator would fit into that structure. An institution's existing procedures, and aligning those procedures with processes for other protected characteristics. So we now are, by well familiar with the Title IX regs, and many folks have specific sexual misconduct policies that sort of apply separately from all the other non-discrimination and anti-harassment policies. And so while now Title VI is going to be covered by these coordinators in New York State, there are still some other protected characteristics that are not going to be caught up in either of those two coordinator positions. And so thinking about how to align this position with those existing policies. I think institutions will also want to give some thought to how employees fit into the picture. Title VI has historically been thought of as regulating, student response for students and their access to programs and activities. So thinking about how a Title VI coordinator slots into policies that may be very similar in sort of content, but would only apply to employees. And finally, the law imposes several other obligations that we'll talk about today. And so in thinking about sort of who can wear this hat and what are all the responsibilities that will fall within it, and whether you're going to need a full-time person or persons to fill this role, you'll want to think about the other obligations, which we're going to cover in a minute. So we can move to the next slide. One of the specific set of duties that are outlined in the law is that when a report is made to the Title VI coordinator, there is an enumerated set of responsibilities. I think this is an area where all of us, regardless of industry, whether this law applies to you or not, are going to want to think about and making sure that your procedures track these types of response requirements, because these are really best practices that anyone would want to be implementing when receiving and responding to a discrimination complaint. There's also importantly a record keeping requirement, and so making a very deliberate effort, I think, to memorialize what is done in response. And I think that's particularly important where sometimes an incident may not be appropriate for a formal disciplinary response, but that doesn't mean that an institution has not done anything in response to the concerns raised, and particularly looking at sort of whether a hostile environment overall has been created through an incident and other connection to other incidents that might be happening in and around campus. And so I think that is an important flag for a record keeping requirement. So you can see the response obligations are listed here. I won't read them out loud, but they are important to make sure that our institutions are all following. Before we jump to the next slide and talking about some notices that are required, I think one of the things that can be interesting for folks from other industries to sort of take away from this is in the education space, we're now seeing, like we were talking about, we've got a Title IX coordinator. We now have Title VI coordinators. We need to have Section 504 coordinators for disabilities. And so thinking about what are some of the benefits of these models. There's some complexities raised of how are we going to fit all these structures and policies together, but what are some of the benefits? And so, thinking about the law's sort of framing of this as a centralized person who has centralized oversight over these processes, and thinking about no matter the industry we're in, sort of how have we set up these reporting functions? Do we have one role or one office with expertise in this area of non-discrimination, or are our responses more diffuse, sort of spread out over a variety of HR functions? And how could we sort of make sure that we are doing right by our employees and our legal obligations, and thinking about whether some sort of centralized and sort of point people is an appropriate practice. It's certainly the trend we're now seeing in higher education. And so I think that's something that folks can think about regardless of industry. We can move to the next slide now to just highlight the annual notice requirement that needs to come from the Title VI coordinator. Institutions are going to be required to send this out to both students and employees, and they're going to need to do this annually every single academic year going forward. This is a pretty straightforward communication, but I think that institutions are going to, again, want to think about how does this new requirement fit within notifications that you might already be providing to your community to cover all forms of discrimination. So thinking about what are the most effective ways to reach students and employees to let folks know about your policies and procedures and how to report. And how can we make this as clear as possible to those community members where we're now navigating different types of roles with the Title IX coordinator, Title IX coordinator, Title IX coordinator, Title VI coordinator, et cetera, et cetera. So now moving to the final requirement from the law. These are the training requirements on the next slide. There's going to be an annual training each academic year for all students and employees to ensure institutional compliance. And there's also a requirement that the Title VI coordinator and any designees that might be appointed also receive training. So while we're waiting for a model training to come out from the New York State Division of Human Rights, which has been directed by the law, you'll want to start taking stock, I think, of existing training requirements, the populations to whom such training is already delivered, thinking about, are you going to want to provide one training to all students and to employees, and how would you coordinate with other employee trainings, such as the already mandated sexual harassment training here in New York State. I think, again, this is a spot where, regardless of industry, things like those annual policy reminders, training, thinking about how might those be things that you could look to in establishing a culture of compliance and a culture of non-discrimination, and thinking about how we can sort of build efficiencies in with some mandated, and then for some industries, what are optional requirements. So I'll end with just talking about the timeline that institutions have to comply with these new requirements in our last slide. So the good news for institutions who one more, I think we might not have advanced the slides. There we go. The good news for institutions that may feel like this is a lot of new requirements is that there is quite a long runway to come into compliance. And so the law becomes effective a year from its enactment. So that takes us to August 2026. And then a Title VI coordinator will need to be appointed 90 days from that. And training obligations will begin the first full academic year after the effective date. So you're going to think about sending out those notices and training the academic year beginning in 2026. Now, of course, that's a long runway. And so one of the things institutions might want to think about, though, is what pieces of the law might you be able to start working on and what might you be able to implement sooner? I think given the increased enforcement attention the Title VI issues have had in the last couple of years, the earlier that folks can get into compliance with these types of requirements, the better off you might be. And so with that, I think I'm going to pass it back to Gabe, who will take us to our next presenter.
Thank you so much, Britt. Really informative information, and there are a number of questions that came in during the course of your comments that relate to some of the nuances that our audience has been thinking about, and I'm sure there'll be more that comes up over the course of these next months as folks move toward implementation. Really glad you could join us, and thanks for bringing us all up to speed. We'll now move to our next presenter, who's Kim Walcott-Agree, and Kim is with us in Westchester. Kim has been on the webinar a number of times previously, and I asked Kim to look into the so-called Wrongful Death Act. We're moving as we shift into fall, though not officially according to the seasons, but certainly in terms of many other measures. We're getting closer to when bills will start to get signed by the governor. And will this be the year for the so-called Wrongful Death Act? It'll be interesting to see. And I know that Kim has been doing some work to get caught up on where things stand. And Kim, please catch us up. We look forward to learning more.
Thank you, Gabe, for the introduction. Good afternoon, everyone. Thank you for joining us. It is really nice to be with you all again. So like Gabe mentioned, I'll be presenting on whether the governor might sign the Wrongful Death Act. Just to start off with a bit of background and legislative history on the act. So the act is actually known as the Grieving Families Act, and it's a bipartisan proposal to amend the wrongful death statute, which hasn't really been amended or changed since its enactment in 1847. Under the current statute, a decedent spouse, child, parent, or state representative may recover economic damages only. So things such as funeral costs or lost wages for any wrongful death action. And since 2022, the legislature has introduced 4 different versions of the Grieving Families Act. The latest version was passed in the New York Senate and Assembly back in June 2025, and it seeks to expand damages to include uncapped emotional damages, so things such as grief, anguish, or loss of companionship. It seeks to extend the statute of limitations to bring these claims from 2 years to 3 years. It seeks to broaden the pool of eligible claimants from the others mentioned earlier to now include surviving close family members, including domestic partners, grandparents, and siblings. So a much broader pool of claimants. And lastly, it seeks to retroactively apply these amendments to deaths occurring on or after January 1st, 2022. So in terms of Governor Hochul's prior stance on this act, she's actually vetoed the first 3 versions of the bill. So that was between 2023 and 2024. She acknowledged in her veto statements that while the bill's intent to support grieving or has the intent to support grieving families, she has concerns about the expansion of damages and the eligible claimant pool, and the potential economic impact, leading to higher costs for patients, consumers, businesses, and an increased insurance premium. Notably, version 4 of the bill is very similar to version 3, so it didn't address any of the prior concerns that Governor Hochul raised. in terms of some of the implications for employers. If this act were to pass, it could increase litigation costs and jury awards significantly, actually, from what I've observed from some of the states that already have this act in place, especially due to the subjective and uncapped emotional damages and the larger pool of potential claimants. It could drive up workers' compensation and liability insurance premiums, and it could also expand employers' exposure in work-related wrongful death claims. So in terms of when this bill, or when it will get to Governor Hochul and whether she'll pass it, we don't know the exact timeline, but based on the history of the prior versions, we can expect it to get to her desk by maybe late 25 or early 2026. And given the legislature's failure to address some of her prior objections, another veto is possible, but again, uncertain. And I think this is the case because we're in sort of a different landscape currently, and there are several things that could influence the decision that she makes this time around. So firstly, version 4 passed with strong majorities in the Assembly and the Senate, suggesting that the legislatures may have sufficient votes to override a veto and make the bill law without executive approval. Second, Governor Hochul announced her 2026 reelection bid, and advocates and lawmakers are hopeful that she may be a bit more receptive to compromise to avoid another veto in order to maintain the support of her key constituencies. She has stated in the past, both in interviews or in her veto statements, that she supports the principle of the bill to expand the compensation for grieving families in these wrongful death actions, but she's also indicated a willingness to advocate for or support a more conservative version of the bill. Lastly, New York remains an outlier in that its wrongful death statute focuses only on economic damages, and the idea of incorporating emotional damages is gaining nationwide traction. So this is another incentive for New York to get behind expanding the scope of damages available under this bill. So again, bond attorneys, we've been monitoring it, and we'll continue to monitor any developments, and I'll be here to share them with you. Thank you all so much. Thanks, Gabe.
Kim, thank you. And, something else we'll be watching is to see, whether the governor would pursue a chapter amendment, which is essentially, rewriting the language in a way that allows her to sign with greater comfort, maybe striking that more conservative, as you call the position. But that is ahead of us, and we're really just glad that you'll be monitoring this for us as we move more so formally into the fall. So let me shift to our next speaker, who is Jillian. And again, thank you, Kim. Jillian is with us to talk about ghost networks, as they are sometimes referenced or otherwise labeled as, excuse me. And there is a bit of backstory here. What we are now seeing is some enforcement. So Jillian is going to tell us about both. Jillian, thank you for joining us from our New York City office.
Hi, everyone. As Gabe mentioned, my name is Jillian, and I'm an attorney in the New York City office. So we recently covered New York State's new network adequacy regulations, which took effect on July 1st, 2025. This presentation is also going to touch upon those regulations, but its focus will be on its requirements regarding network directories and the recent enforcement of so-called ghost networks by the New York State Attorney General. Next slide, please. Now, just a brief recap. New York State implemented these new regulations, and they were essentially focused on improving access to behavioral health services, such as mental health and substance use treatment services. These regulations created new requirements for covered plans. You can see a brief list on the slides, but to summarize very quickly, it essentially created new wait time standards, required that directories be updated, and that an access plan be established. Next slide, please. Now, as I mentioned previously, the one requirement that we are focusing on today is network directories. So under the new regulations, these network directories must have specific information about their in-network behavioral health providers. Again, this is not a complete list on the slide, but some of the information must include practice locations, scopes of services, and linguistic competencies. These directories must also be routinely updated to ensure that their information is up to date. And again, not meant to be an exhaustive list, but rather just a brief recap of what this requirement entails. Now, when these directories are not updated, or in other words, it has inaccurate listings or unavailable providers, it creates these so-called ghost networks that make it difficult for people to access treatment. And these alleged ghost networks are important to this presentation because the AG office initiated an investigation in December 2023 to determine whether this was occurring within directories statewide. Next slide, please. So in this investigation, the AG conducted a statewide secret shopper survey of health plans. And this study reported that 86% of the listed providers were unreachable, not in network, or not accepting new patients. As a result of this investigation, the AG office has mentioned that they are seeking to increase their enforcement to ensure that directory information is being regularly verified and updated. Next slide, please. So this past August, the first legal action stemming from this 2023 investigation took place. In the 2023 investigation, the AG office found that all the providers listed in MVP Health Plans directory were either unavailable or unreachable. The AG and MVP Health Plan actually entered into a settlement agreement. And in this agreement, MVP Health Plan is required to pay a $250,000 fine and to reimburse any members who paid more than they should have for mental health care due to their directory. Additionally, MVP Health Plan has to overhaul its directory to ensure that all of its listings are accurate. And I see I'm running out of time, but if you have any follow-up questions on this, please don't hesitate to contact us here at Bond.
Thank you very much, Jillian. And it's a brief snapshot of this topic. It's one that touches a number of different corners of our client arena. You know, we represent both plans and providers, and we know that there are many of you that have questions. So don't hesitate to reach out to Jillian or to me, and we can dig in offline with you. But let's turn in the interim to our last presenter for today's program, and that's Mark Saracino, a fellow Mets fan with us from Suffolk County today. We are glad to have you on the program, and it's the second time on the webinar. First time, to my knowledge, talking about Juan Soto and the Mets. So what do you have to tell us?
Yeah, that's right. Thanks so much, Gabe, and pleasure to be back on the webinar. So yeah, we thought we'd make this last segment a little more fun, talk about some baseball. Baseball's in full swing right now, no pun intended. Both New York teams are in their respective pennant races. The Mets are looking up at the Phillies, Yankees are looking up at the Blue Jays. And while we can certainly, you know, criticize the Mets for a variety of issues like we can do every season, we certainly can't criticize the owner, Steve Cohen, for going out this past offseason and spending some money and really locking down a key player, Juan Soto. And I'm sure even if you don't follow baseball, you probably have heard that name in the news or just on sports talk radio. He's been well spoken about for the last 5 or 6 months after this contract. So, you know, young guy, 26 years old, really a star player in the MLB. I'm not going to go through his stats, but really just a superb player. So we locked him in. The Mets locked him in for a 15-year contract, $765 million, which is just a lot of money, as you know. It's actually the largest contract in MLB history. It just recently surpassed Shohei Ohtani's contract. That was for $700 million back in 2023. And just when you thought it couldn't get much more expensive than that, well, Juan Soto came around for 765, and I wouldn't be surprised in the next couple of years if we see a contract even larger than this one. One of the key differences between Juan Soto's contract and Shohei's contract, Shohei deferred a lot of his money, meaning he's not getting a lot of money for the first few years as part of his contract. He pushed it back to the back end of his contract, really to circumvent the luxury tax issues that the MLB has in place. Juan Soto did not do that. So Steve Cohen is paying Juan in real time every year. So just to go over some of the basic contract terms, you know, it's 15 years, as I said, $765 million. He received a $75 million signing bonus. So as soon as his pen hit the paper, his bank account went up $75 million. if you break down the math, it's quite interesting. So, 162 games in a season, you kind of take the averages of his at-bats, his swings per game. So he's making roughly $314,000 a game. And, depending on how many swings he takes per game, he's making anywhere between $40,000 to $80,000 per swing. So, every time he swings and he strikes out, it's warranted to be upset because that's, $50,000 down the drain. On top of that, he has a lot of performance incentives. So if he wins MVP, he gets another $500K. If he wins the Silver Slugger Award, the Hank Aaron Award, if he becomes an All-Star, which he did not for the 2025 season, he'll get anywhere from another $100,000 to $350,000 for each of those awards, respectively. So a lot of money there, obviously. He also negotiated some perks. So he gets an executive level suite. He gets a bunch of seats for his family and friends. And when I say he negotiated it, I really mean Scott Boras. That's his agent. That was his attorney. You might have heard that name as well. In this particular industry, the MLB, he represents a lot of big time players. And according to Steve Cohen, he's not the best to work with on the other side of the deal table. He really works to get the players a lot of money. And that's what happened here. So that's sort of the business terms, right? And again, it's just a contract, just like, so I'm in the mergers and acquisitions group here at Bond. We do contracts all the time for mergers and acquisitions of companies. You can think the same way for players, right? And athletes. They're signing a contract. They're, Steve Cohen, the Mets, they're acquiring Juan Soto. So those are the business terms. A few key legal terms that I wanted to touch base upon, because you probably have heard these come up too. There's an opt-out clause in the contract, right? So after 5 years, so in 2029, Juan Soto can elect to opt out and kind of, go back in the market to see what he can get. The Mets can actually override that and not allow him to opt out if they pay him another $4 million a year for the remaining 10 years. So that'd be another $40 million. So the total value would become $805 million for the entire contract. So that's the opt-out clause. There's also a no trade clause. So, just like it sounds, he cannot be traded. So if Steve Cohen wants to get rid of him for whatever reason, he cannot do that unless Juan Soto approves. So it really limits sort of the team flexibility in that respect. And it's a great addition for Juan Soto. And then obviously with any contract, you need consideration, just contracts 101. Both parties have to be giving up something on both sides of the deal. Otherwise, the contract is non-enforceable. That's why a lot of times you'll see a contract put in place where, the consideration is $1, right? There needs to be something that's given by both sides. It could be services, it could be money, it could be both. Here it's sort of a mix, right? Soto's providing services, his playing ability to the team. His consideration is also not being able to go out to other teams, so he's giving up something, which is another form of consideration. And obviously, on the other end, Steve Cohen his consideration is upwards of $805 million. So, in conclusion, this is a massive contract, one that's been widely spoken about over the last 6 months in particular. Great news for the Mets. It's a really good player, and as you can see from his stats of late, he's really been contributing to the team, and we can only hope that this carries forward through the postseason. So obviously, if you have any questions about this, or if you want to just commiserate in some of the Mets' inconsistencies, more than happy to do that. But I'll give it back to Gabe now. Thanks so much.
Thanks so much for the fun interlude discussing, things other than what sometimes we cover here on the webinar. But as you point out, business terms are business terms, and there are a lot of similarities in terms of how that deal was negotiated relative to the other types of deals that Bond helps out with, and our team on Long Island and elsewhere. So Mark, thanks for giving some insight into how you and others think about these kinds of structures. And with that, let's go to our last slide here. We have some upcoming events that are particularly useful for those looking for labor and employment guidance, best practices for avoiding liability and hiring and termination. If you are an employer and you are in Albany, look out for November 4th, Binghamton, October 30th, and onward, as you see on the slide. It's alphabetized by location. This is something that, we are delighted to bring to you. If you'd like more information, just go onto our website and specifically the events subhead on the website, and you can get more detail. With that, Kathy, would just ask you to put up the next slide where you can see the various emails for each of our presenters. If anybody has a question, reach out to any of us today, because that's what we're here for. We want to be of help to you, whether online here during the webinar or offline. I won't be your host next week. That'll be happening on the 9th, but I will be back with you on the 16th. I look very much forward to it. In the interim, to all of you getting back into the swing of things as summer comes to its unofficial end, good luck. It takes a little bit of transition for all of us, but there are a lot of good things, knock on wood, ahead as we move into fall, and really glad to share this afternoon with you. Have a terrific remainder of your day and week.